We start with oral arguments from Mr. Zhao Wang, attorney for Ms. Ames. Mr. Wang begins by describing the situation that led to the lawsuit.
Mr. Chief Justice, and may it please the court. Marlene Ames has worked for the Ohio Department of Youth Services for over 2 decades, and in 2018, her year-end performance review described her as being very competent in her role, a pleasure to have on the team, and always willing to assist others. But in 2019, she experienced 2 adverse employment actions. First, she sought a promotion to bureau chief, for which she was qualified, for which she applied, and for which she interviewed. But neither she nor the 2 other heterosexual employees who applied and interviewed got the job. Instead, the job was held open for 8 months before going to a gay employee who neither applied nor interviewed for the position. And second, Ms. Ames lost the job that she was in, and she lost it and was replaced by a separate gay employee who also did not apply or interview for the position.
The situation described by Mr. Wang certainly does seem to show discrimination. First, 3 heterosexual applicants for a job are denied. Then the job is left open for months until a homosexual employee was given the job, even though they never applied for nor interviewed for the position. Then Ms. Ames lost a job for which she had been given excellent performance reviews, only to have the vacancy filled by yet another homosexual person who neither applied nor was interviewed for the position. Seems pretty cut and dried, both to me and to the Sixth Circuit Court of Appeals.
Based on these facts, the Sixth Circuit held that Ms. Ames had satisfied the usual requirements for stating a prima facie case of discrimination under Title VII, but she could not proceed because of the background circumstances rule, which the Sixth Circuit described as an additional showing unique to majority group plaintiffs.
Wait. Ms. Ames stated a prima facie case of discrimination, a fact presumed to be true unless disproved. But because she wasn't a minority, she needed to prove more?
The narrow question before the court today is whether this judge-made rule is consistent with Title VII, and we submit that it is not. It's not because this court has said that Title VII aims to eradicate all discrimination in the workplace. But the background circumstances rule doesn't do that. It doesn't eradicate discrimination. It instructs courts to practice it by sorting individuals into majority and minority groups based on their race, their sex, or their protected characteristic, and applying a categorical evidentiary presumption, not in favor of, but against the non-moving party, based solely on their being in a majority group, however you define it.
Title VII was created to get rid of discrimination. Yet this background circumstances rule, something made up by courts and is not law, actually tells courts to discriminate. Again, this is not based on a law passed by Congress, but by a rule established by one or more judges in violation of the law.
But that's not consistent with the statute that tells us that we are supposed to protect all individuals from individual discrimination based on the individual case. And it's not consistent with McDonald versus Santa Fe Trail, where this court says that all individuals, whether in majority or minority groups, are protected by Title VII under the same terms and the same standards. For these reasons, we urge the court to reverse the judgment of the Sixth Circuit. I welcome the court's questions.